Sarah and Tom, can you both hear me still?
Yeah.
Yes.
Wonderful. Okay, we should be broadcasting now. Hi, everyone. I'm very excited to welcome you to today's conversation, reviewing some of the key decisions from the Supreme Court this term. My name is Laura Safdie, and for the next hour, we'll be speaking with two giants in Supreme Court litigation, Tom Goldstein and Sarah Harrington, attorneys with the Goldstein and Russell Law Firm and authors for SCOTUS Blog. Today's conversation is co-sponsored by the American Constitution Society, the Federalist Society, SCOTUS Blog, and Casetext. Because of the number of viewers we have, we can't have two-way audio, so please email any questions for Tom and Sarah to support@casetext.com. That's support@casetext.com. We've already gotten a handful, and we'll address as many as we can during this conversation. I'm going to take just a minute to introduce our panelists today, though I'm sure most of you are familiar with their work. Tom Goldstein has served as counsel to a party in well over 100 merits cases at the court and has been counsel on more successful petitions for cert over the past decade than any other lawyer in private practice. Tom's the founder and publisher of SCOTUS Blog, which we all appreciate very much for their valuable commentary and analysis of Supreme Court decisions. Sarah Harrington has argued 20 cases in the Supreme Court. I don't know if that number is up to date, Sarah, so tell me if it's more than that.
It's 21 now.
Okay, I'm sorry. I'm very sorry. And has served as counsel in dozens of others. She's handled a wide range of topics before the court and has previously served as an assistant to the U.S. Solicitor General and an appellate attorney in the Civil Rights Division at the U.S. Department of Justice. This is obviously a very critical time in our country, and this is a very critical conversation, so I appreciate everyone taking the time to join us today. Please join me in welcoming Tom and Sarah.
Great. Thanks so much, Laura.
Of course, and thanks to you.
Go ahead. Sorry, we're going to start off by talking about just kind of some stage setting topics so people can kind of understand where the court is right now and how it fits in with the rest of the world. And I'll start by talking about how the court has been dealing with the pandemic because they've been going through it just like the rest of us. As we know, the pandemic kind of really hit this country in March and everything shut down. And the court was set to hear argument in 20 cases over their March sitting and their April sitting. They pretty quickly canceled the March sitting, and then that was followed by canceling the April sitting. And then there was a time where no one knew what was happening. They shut the court to the public. They issued some sort of litigation-friendly rules extending deadlines for people. They were trying to be accommodating, but no one knew really for a little while what was going to happen with the arguments. And eventually what they did is they decided to hear 10 of those cases, to hear 10 arguments over the phone in May. So we had an unprecedented May sitting and an unprecedented telephone sitting. This had never happened before. I guess they had canceled arguments during the 1917 pandemic, the Spanish flu pandemic. So they said, oh, this isn't unprecedented, but they'd never heard arguments over the phone before. So that was kind of a fun adventure. And the thing that was really interesting that they did is they decided to simultaneously broadcast the arguments to the press, who then simultaneously broadcast them to the public. And so it was the first time that anyone anywhere could listen to oral arguments as they were happening from the comfort of their homes. And I think that was a great thing for the court and for the public. It was like a great kind of window into things that happen at the court. Now, the arguments were not exactly like they normally are. Normally, as most people probably listening know, the arguments are kind of a free-for-all. It's a lively exchange of ideas, lots of interrupting. That doesn't really work on a telephone conference call, and the justices opted not to do a Zoom argument like some courts of appeals are doing, or some kind of video conference argument. And so what they did is they decided to take turns. And so each justice in order of seniority had a turn to ask their questions of the counsel. So there were a couple benefits of that. One was that we actually heard questions from Justice Thomas, who kind of famously never asked questions. And he has said one reason he doesn't ask questions is he doesn't appreciate the free-for-all. He thinks it's preferable to actually hear the answers from the lawyers. But he actually has pretty good questions, and so it was interesting to hear his perspective, and he asks questions in every case. I think it was a little hard for the advocates in a way because sometimes you get information from the justices based on who's asking more questions or fewer questions and who's interrupting whom, and you didn't have any of that dynamic. But overall, I think it was a success. The court has not said what they're going to do next term. They've pushed off 10 cases that they were going to hear this last term into October. They haven't said how they're going to hear those arguments. I think we can assume it's going to be over the phone again, at least until everyone on the court is vaccinated. They're obviously Many of them are in a demographic that is at high risk of serious complications if they get COVID. And so I don't expect that the court's going to open anytime soon to the public or even to in-person arguments. And then the other thing I'll mention is the court has seen some COVID-related litigation, these sort of emergency motions coming up related to voting restrictions or people trying to make it easier to vote during the pandemic, and also some about closing businesses and churches and large-scale gatherings. And so I think we can expect to see more of that as this pandemic continues. So that's sort of like the court in the pandemic. Tom's going to talk to us a little bit about the Chief Justice and his new role at the court, or maybe it's not a new role. Tom, you're muted.
We can't hear you.
Sorry, there we go. I unmuted then remuted. With the retirement a couple of years ago by Justice Kennedy, we've been interested in learning who it is emerges as the court's kind of pivotal, maybe not swing vote, but dispositive vote in the tough 5-4 ideological cases. And we have expected that John Roberts would fill that role, and this term he largely did that. But he did even more than that. Now, it was a significant term for the chief. We've already forgotten the fact that he oversaw the impeachment trial of the president, and so he was very busy there. He had a little medical adventure on Father's Day. He passed out and hit his head and was hospitalized. We didn't learn that until later. But his principal role obviously was at the Supreme Court, managing the things that Sarah's talked about with respect to the pandemic and how the court responded, managing the federal judiciary's response, because he's the Chief Justice of the United States, not just of the Supreme Court. And so there were a ton of issues related to that. But doctrinally, when it comes to the big cases and the Chief Justice's votes, it's been a very, very kind of distressing and depressing series of results from strong judicial conservatives, but I think those reactions are probably a little bit overstated. In the cases that we're going to talk about, we'll hear about the chief's pivotal role, the fact that in the cases that we're going to talk about, he was in the majority in all of them, and that's no surprise because in 60 of the 62 cases that the court decided by opinion this term, he was in the majority, which is unheard of. An incredible proportion. There was one significant Native American tribal case that he wasn't in the majority in, but every other significant case he was. And not just that, his kind of approach to each of the individual cases ended up being controlling. Now, a number of the results this term were kind of on the progressive-ish side of things. We'll talk about the abortion case. We'll talk about the Title VII case, which really probably was a significant victory in that direction for the left, but also DACA. And what I think is probably the better take on what the chief is doing is that he is being an institutionalist. He wants to keep the Supreme Court out of the major social and political fights of the day, wants to leave a lot of that stuff to the political branches. But he is, is a believer, for example, in stare decisis, and that explains some of what he's doing. But he is unquestionably a conservative justice. There are high-profile cases, for example, involving the Affordable Care Act that have caused a lot of conservatives a lot of distress. But across the kind of broad array of cases that Supreme Court is hearing, major cases like Citizens United, the religion cases that we'll talk about this term, and over and over and over again, he is a solid conservative vote. He's just not as nearly as aggressive as the late Justice Scalia or Justice Alito, as Justice Thomas. He's much more of a kind of careful, methodical vote for conservatives, and occasionally, that ends up being very, very disappointing. And there are outlier cases either way. It's in the nature of someone being the kind of center fifth vote that they're going to end up on both sides of the issue sometimes. But it'll be interesting to talk about his perspective in individual cases. But I think that this really was the term that kind of really cemented this as the Roberts Court, because essentially you could not win a major case without his vote.
That's a really important note, and I think something that's going to come up throughout our conversation today. Before we dive into the cases, just a personal question, since Sarah, you raised this issue. What's it like for an advocate now preparing to come before the court in this kind of uncertain time? Like, if you don't know how arguments are going to be heard next term, how does that impact your thinking?
Well, I'll kick that to Tom because Tom has an argument in October, so he can tell you what
Okay.
he's thinking about it.
Very imminent.
Yeah, so I have a case for Google called Google versus Oracle, which is a copyright case about computer software. And it has been a little bit of a puzzle. We got ready for oral arguments and then the court canceled them. We were in the last bunch of cases that were supposed to be argued last term. We have an oral argument date in October now, but we don't know what form it'll take. So a lot of it is the same in the sense of, you prepare and you get ready for all kinds of questions, but the format is, as Sarah said, very, very, very different. It's much more regimented, going justice by justice. And a lot of the kind of other cues that we take, not just who's interested in the case, but kind of even the visual cues that we get inside the courtroom will be lost. And so, for someone who's argued, Sarah's argued, 21 cases, I've argued a bunch of cases, we're used to doing things a certain way. And as lawyers, we're used to doing things at least where we can see the judges who are involved. And to just kind of talk into a phone is a kind of very distant and unusual thing. So we're going to try and moot court the case in the way that we would present it in the actual argument itself telephonically, but Sarah has to be exactly right when she says that that's overwhelmingly likely how it'll go, but nobody really quite knows yet how to prepare. I will say that I did think that although the crosstalk can be really informative and allow good follow-up, I was surprised that these arguments were as informative as they were, because when you aren't getting interrupted all the time, there's much more of a chance for the advocate to get a coherent set of thoughts out and for the justice involved to ask follow-up questions. So I may be in the minority in this, I actually think it's a good process and maybe even a slight improvement.
That's really interesting. I hope that they continue to be broadcast so we can all listen in. All right, why don't we take it away? I think we want to start on the Title VII case. Tom, do you want to kick us off?
Absolutely. So there was a major fight this term that has been brewing over the course of, maybe conceivably since Title VII was enacted, or at least the late 1960s. And it has really taken on great momentum on the question of the extent to which the civil rights laws, including particularly Title VII, protect individuals from employment discrimination on the basis of homosexual or transgender status. And the lower federal courts for a long time had uniformly said, no, Title VII doesn't reach that form of, call it discrimination or just call it employment actions. And the statute says that you cannot take an adverse employment action because of someone's sex. And the general view and the general basis for those decisions in the lower courts was, look, can we really say in 1964, when the statute was passed, that Congress had in mind protecting gay and lesbian employees, transgender employees? And I think everybody agrees the answer is no. On the other hand, there are a number of other things that Title VII has been held to protect, for example, against sexual harassment, that nobody really believes Congress had in mind at the time. And so a couple of courts of appeals over the previous few years have reversed their earlier precedents and held that Title VII does apply to that form of employment action and that form of what is now regarded in law as discrimination. The case came up to the Supreme Court, and I think the general view was that a conservative Supreme Court would be relatively hostile to this form of this kind of claim. And people who work on behalf of gay, lesbian, transgender individuals were, I think, very concerned because Justice Kennedy, when he was on the court, had helped move the law in the direction of much more expansive protections against this form of discrimination. And Justice Kennedy obviously retired, and the real question is, would the Supreme Court kind of pivot back in the other direction? Would there be a broader movement in the other direction because the Supreme Court has kind of led society, arguably, in this direction of recognizing this as a form of unlawful discrimination? And very interestingly, the employees won this case, and not only won it at the Supreme Court, but won it with a 6-justice majority, and even more interestingly, in an opinion by Justice Gorsuch, who is a quite conservative justice. And Justice Gorsuch's opinion for the majority says, look, under our precedent of interpreting Title VII, when we say that you can't discriminate because of sex, that's going to be true if it plays any role whatsoever. And when we interpret a statute, we interpret it kind of by its ordinary public meaning. What do the words mean? And he says for the court, look, when you fire someone because they're homosexual, what you are saying is that I'm doing something differently. Say if it's a male, it's because this man is sexually attracted to other men. And if it was a woman, you wouldn't fire them for that reason. And therefore, sex plays some role in your decision, and just as a matter of plain and ordinary meaning of the terms and the court's prior precedent, we're going to say that Title VII applies, and the same is true for transgender individuals. And the opinion in that respect is completely sweeping. It doesn't hold back. It does identify a number of issues that are still going to come before the courts later on. The most significant one will be whether there are, under the Religious Freedom Restoration Act or other principles, exceptions to the application of Title VII in this context for individuals or for businesses, for people who have religious convictions that are implicated by the application of the statute. In addition, there are specific applications of the statute, particularly ones under other civil rights statutes involving issues for sex-segregated bathrooms and locker rooms and the like. And the majority just says, we're going to put all of that to the side. Not surprisingly, it did generate a very significant and vocal set of dissents, particularly from Justice Alito and Justice Thomas, a very conservative vote saying, what in the world are you doing? You were just legislating here. Congress has had a bunch of bills to accomplish this, and it has not passed any of them. Nobody really believes that Congress could possibly have had this in mind at the time. So it is really interesting to look at the different votes. We have Justice Gorsuch, of course, writing the majority opinion. John Roberts joins that opinion. And so that's one, indication, again, of the phenomenon we talked about, the importance of his vote. And then you have Justice Kavanaugh, who does dissent, but does it in a much more empathetic and sympathetic way of saying, look, I really do think that maybe the majority is on the side of the angels here, but this is just not our job. And that too will kind of be a theme in a lot of what Justice Kavanaugh does in terms of coming out in more conservative directions, but with a kind of more moderate voice. So this is the most significant progressive win at the Supreme Court this term, and maybe in a couple of terms, and is really, really very interesting for the fact that you got the wholehearted endorsement of Justice Gorsuch and the Chief Justice.
Yeah, this is obviously a very, very important case. We have a bunch of questions coming in about it. My first question is kind of taking a step back, thinking more broadly, like, what does this mean for statutory interpretation, more broadly speaking? If the majority found the text to be unambiguous, despite, you and I think everyone acknowledging that there's no way that the passing Congress believed the words to mean that. And we have the folks in the dissent who are looking at original intent, what statutes would count as ambiguous under that standard, and how often do you expect to see, evidence of congressional intent or legislative history moving forward?
Well, I do think that Justice Gorsuch is very serious about this. He follows in the kind of Justice Scalia tradition, although I don't even know that Justice Scalia could have ended up in the majority in this case. So it's a very justice by justice thing, and to be honest, a very case by case thing. This case was so prominent, so prevalent, got so much attention that you almost have to treat it as sui generis, I think. I don't know that you can kind of extrapolate from this that there's going to be any change in the court's overall approach to statutory interpretation. And remember, this majority opinion is really, really very reflective of Justice Gorsuch's, precise approach to these sorts of things. The members of the left of the Supreme Court are super happy to go along with this and join it, even if they would be, more inclined in other cases to talk about the broader social purposes of things.
We're all textualists now, right?
We're all textualists today. because it's super convenient to be super textualist. I think I'm a bit of a legal realist, and I think that there are different drivers for each member of the court. I also think you can think about the Chief Justice in these terms, and I don't doubt that he joined it because he does believe that this is the the meaning of the terms. But I do think that here you have a situation where he probably feels the momentum that has been created by the Supreme Court and doesn't want to kind of change directions radically, and probably views the court as playing a really positive role in this context. And probably the most interesting thing about it is the fact that this argument that, look, a bunch of bills were presented to Congress and were turned down, honestly, pretty obviously, because they couldn't get a majority for them. And that is not persuasive to the court. The court is just like, we're not going to give weight to failed legislation. But I wouldn't say that you could anticipate really other cases by the vote here, other than it's a strong indication that Justice Gorsuch is going to look at these questions this way.
That does make a lot of sense. We have an interesting question from a listener. How did the court's discussion of the but-for causation standard affirm or modify any previous understanding of that term? If but-for causation does not have to be the sole, main, or even predominant factor, what does then motivating factor standard under the statute mean?
Sure. So as I said, the statute says because of sex. And the essential move, I think, here, kind of in the broader interpretation of the statute, of Title VII generally, that Justice Gorsuch's opinion makes, is to say, look, we look at our prior precedent and we say, if sex, that is to say here, the fact that you're male or female, really has placed any role whatsoever. We don't care if there are other things that are motivating the employer, for example, just a hostility to homosexuals, hostility to transgender individuals. That is neither here nor there. The statute asks, according to Justice Gorsuch, would you have done something differently? Did it have any effect on your decision whatsoever that this person was a man or a woman, so that if the genders were reversed, you wouldn't have treated them the same way? And Justice Gorsuch says, so long as that plays any role, that's enough. And that may have, as the question suggests, significant spillover effects, where you have employment actions that are justified or not justified, but are motivated by a bunch of different things. And if sex plays any role with respect to any of them, those Title VII plaintiffs can expect to win. So I think in terms of kind of the Title VII employment plaintiffs bar, the decision has potentially broad significance beyond this kind of more socially fraught context.
Understood. So what comes next now? Can we expect to see these protections against discrimination for sexual orientation and gender identity extending in other contexts, education, housing, et cetera? Do you guys see this to be kind of a smooth expansion, or is this going to be fraught with battle?
I think that there are two different trajectories for it. Number one is outside employment, as you say, housing, for example. This formulation, because of sex, and similar formulations are pretty common in anti-discrimination law, generally in federal law, but also in state law. And I don't think you're going to have really good reasons for saying that we're going to protect against these kinds of actions in employment, but not in housing or something like that. On the other hand, I do think the court has left itself a lot of room to maneuver with respect to particular applications, and especially in the context of religious objections. I do have the feeling, and we'll talk about religion later on, that the court is carving that out. And Justice Kennedy's opinion, even back in Obergefell, when it comes to recognizing a constitutional right to same-sex marriage, is carving out the possibility that there will be sincere religious and moral objections that the law will need to recognize. So those are, I think, the fraught set of questions, the particular applications like bathrooms and the exemptions on the basis of religion. I do think it'll be relatively smooth in the application to other forms of anti-discrimination law.
We'll have to watch it closely. Okay, thanks. Why don't we move on to the DACA case?
Great, so I'm going to talk about DACA, which is the Deferred Action for Childhood Arrivals, what we think of as the Dreamers. This is the program that was implemented by the Obama administration in 2012 to protect young adults who were brought here as children without immigration documents, and so have been here undocumented. And these are people who have been to college or enrolled in the military, who have no serious criminal background, have submitted to no serious criminal record, have submitted to background checks, et cetera. And the DACA program did two things for these people. And I should say that's 800,000 people who signed up for this program. So it's a huge number of people. The two things are it deferred removal of these people. It said to them, we are not going to remove you from the country for a 2-year period, and you can renew that period when it runs out. And then it also gave them benefits. It said during the period of deferral of removal, we are going to let you work legally. We're going to let you get benefits like your driver's license and health insurance and things like that. So that was the program that was put in place in the Obama administration, as I said, in 2012. They also then expanded the DACA program and implemented a related program called DAPA, which is Deferred Action for Parents of Americans. So for people who came here undocumented, but then had children here, and those children are American citizens. So the DAPA program was challenged in the Obama administration, and it was found to be illegal in the Fifth Circuit, and that went up to the United States Supreme Court. And in 2016, it was affirmed 4-4 because that was the year that Justice Scalia passed away. And so, so that affirms a 4-4 tie in the Supreme Court, affirms the lower court decision, and so that program was found to be illegal. So the Trump administration comes in 2017, and they pretty quickly issue an order that rescinds the DACA program. And the reason they give is they say there's a decision issued by Attorney General Jeff Sessions saying, based on the decision, the Fifth Circuit's decision in DAPA, in that case, we think that the DACA program is also illegal. And so we're shutting it down. And that's the only reason they give, basically. We think it's illegal. And they shut it down. And so the decision to rescind DACA is challenged in a number of courts, and that decision is struck down in a number of different courts. And the basic reasoning is something along the lines of, well, you didn't really give a full explanation. Just saying it's illegal doesn't really explain why you're doing it. It doesn't show us that you're considering the sort of the implications on the people who have benefited from the program, the reliance interests. There's a certain amount of discretion that's being exercised here by the executive, and just saying we have no discretion, we think it's illegal, isn't enough of an explanation. And the administration offered sort of other explanations in the course of the litigation, and most courts said, well, you know, we're not really allowed in these Administrative Procedure Act cases to consider post hoc rationalizations. The only thing we can look at is the decision that you gave at the time of the action that's being challenged. And so the cases went up to the Supreme Court, and they just sat for a while at the Supreme Court. It was kind of interesting. The same thing happened with the Title VII cases. This was not this past term, but the term before. These two sets of cases, they just sat for a long time without the court making a choice about what to do with the cert petitions. And many people thought it was because in Justice Kavanaugh's first term, they just wanted to sort of kick off politically charged decisions as long as they could. I think in the DACA cases, they were just kind of hoping that the elected branches would get it together and reach a legislative solution for how to help the Dreamers. Of course, we know that didn't happen. It hasn't happened still. And so the court eventually granted cert in these three cases. So there were sort of two categories of issues in the case. One was whether the decision to rescind DACA is reviewable at all in a court. And the other was whether the way that the administration rescinded DACA complied with the Administrative Procedure Act, whether it was a legal rescission of DACA. Now, interestingly enough, everyone basically agreed that the executive had the authority to rescind DACA, that if the Obama administration could put it in place, the Trump administration could take it back. So that wasn't really the question. The question was whether the way they did it was the right way to do it. And so it went up to the court. And, you know, one interesting thing about this is all along, the administration could have mooted those cases by issuing a new decision to rescind DACA that had more reasons, that had all these extra reasons that they had given in the course of the litigation. And they didn't do that. And, you know, we're only left to speculate about why. But it is, it's worth noting that DACA is a very politically popular program. You know, a big majority in the country think that there should be something that's done to protect the Dreamers. And so there was speculation that they just didn't want to sort of be on the hook for the policy decision about rescinding DACA. And in fact, interestingly enough, at the oral argument in the case, the Solicitor General for the US, Noel Francisco, was arguing in defense of the decision to rescind. And he was asked, I think it was by Justice Ginsburg, basically, can you say, standing here in front of us, that you own the decision to rescind DACA? And he said, we own it. So I thought that was a pretty remarkable moment in the oral argument. You don't see that very often. But ultimately, this decision came down and it was 5-4, with, again, the Chief Justice and the 4 more liberal justices. I shouldn't say again, but we'll see that again in the rest of this conversation. And they said the decision to rescind DACA was illegal. And so they said first it's a reviewable action, but then they said, and the Chief Justice wrote the opinion, he said it was illegal what they did because they were entitled to rely on Attorney General Jeff Sessions' opinion saying that we think DACA is illegal. But that opinion relied on the Fifth Circuit's reasoning, which only talked about half the program, only talked about the benefits that were given to people who were recipients of DACA. And it said that the benefits part was illegal, that the executive didn't have any authority to do that. But it didn't talk about the decision to defer removal. And the Chief Justice described that as really the heart of the program, that allowing people to stay in the country was really the heart of DACA, and nothing in the administrative record justifying the decision to rescind DACA really even addressed that, whether that was illegal, whether it was good policy, bad policy, reliance interest, none of that. And so the Chief Justice said, that's a violation of the Administrative Procedure Act. You have to give kind of a fulsome explanation. We can't consider your post hoc rationalizations. That's kind of bedrock administrative law. And I think, so it's interesting to think about this decision in the context of the Chief Justice's role of the court, as Tom talked about, as an institutionalist. So one thing that's really important to him, like super important to him, is that the public view the court as a non-political, non-partisan part of the government, right? It is the part of our government that's not elected. He wants it to be seen as not political. And he gets very irked when these political messes get dumped in the lap of the court when they should have been handled in the elected branches. And so it's interesting to think of this case in the context of the census case that came out last year, where it was a similar kind of thing. The administration had tried to put a citizenship question on the census questionnaire. And the reason they had given was that they wanted to do it in order to facilitate enforcement of the Voting Rights Act. And the Chief Justice, and after the argument in this strange series of events that I won't go through, but a lot of information came out to suggest quite strongly that that was not, in fact, the real reason that they put the question. They wanted to put the question on the questionnaire. And the Chief Justice in that case, too, was the fifth vote to say, look, you can do this, but you have to be honest about why you're doing it. You have to give us a real explanation for the policy choices that you're making. And you see similar kind of themes in the DACA decision. He says at the end of the decision, I'm not saying anything about whether it's good policy or bad policy. What I'm saying is the people who make the policy need to give us the real explanation for why they're doing it. And so I think that's his way of sort of trying to push the political mess back off the Article 3 branch of government back into the elected branches. Now, he also said not all the liberals joined this part of the opinion. He rejected arguments that the rescission of DACA was racially discriminatory. Justice Sotomayor declined to join that part of the opinion, but the other three joined that. And so the ball is basically now back in the executive branch, back with the agency. And the president immediately got on Twitter and criticized the opinion and said he wants a legal solution to this problem. I'd be surprised if we see anything before the election that moves the ball one way or the other, but we'll have to wait and see.
And that last comment is based on kind of a political assessment of what the administration is willing to do leading up to an election, or any more than that?
Yeah, I mean, it's partly like it takes some time to actually go through the procedures that are required by the APA. And so at a certain point, they're just going to run out of time to do a rulemaking before the election. But I also think, the reason they relied all along on this justification saying it was illegal rather than just doing a new rulemaking was that they probably don't want to own it. Like, as I said, the DACA is a very popular program, and I think they seem to be reluctant to sort of take ownership of ending it. And in fact, the president has repeatedly said, we want to help the dreamers, we're going to help the dreamers, we want to reach a solution, and even while we're sending DACA. And so I would just be a little surprised if anything happens now in the last few months.
We have a question related to this case from one of the viewers that asks, will it be easier now for the current or future president to bypass Congress with an executive order? It's almost like this case, my editorialization, it's almost like this case and the census case both give like a real roadmap. Like, here's how you get around this. Just do these procedures and you'll be fine. That the administration has chosen not to. So the viewer is asking, do we see this extending into future executive orders?
Well, it'll be interesting to see. So I don't think, I wouldn't say it's a roadmap for getting around Congress. In the census case, there was a large part of the opinion about whether, in fact, it was legal under the statutes that govern the census to put the question on, and the court, in a closely divided court with a different lineup, with the conservatives against the liberals, said that yes, it was legal. Here, there wasn't really a determination of whether the program itself is authorized by statute. There was more a conceit of if one president can put it in place, the other one can take it back, without really an analysis of whether, like, the Immigration and Nationality Act permits this kind of categorical deferral of removal. I do think, the Chief Justice is now pretty strongly on record saying, we're not here to judge the policy of it's not an executive order, but of these administrative actions, the administrative rulemakings. It's really our job is to make sure that you're going through the procedures that Congress has set forth. And so, I think I would expect future administrations to test whether he means it.
Understood. I think that's all we have in questions from the audience for this case. So why don't we move on to talking about June medical services?
Sure. So this was the terms abortion case. Abortion always being an incredibly fraught issue at the Supreme Court and for society and for culture, for politics. This case involves a Louisiana statute that required doctors who perform abortion services to have admitting privileges at a hospital within 30 miles. And the notable thing at the Supreme Court is that this statute is basically a twin of a statute enacted by Texas and struck down by the Supreme Court in a 5-3 vote with Justice Kennedy in the majority. So this is probably the most significant case of the term when we are really looking at the question of what does it mean that Justice Kennedy is no longer on the Supreme Court, because it could indicate a completely different trajectory for the court on the pivotal question of abortion. The Fifth Circuit had upheld the statute on the ground that the record relating to Louisiana was different from the record relating to what would happen in Texas. The district court in the Louisiana case, this case, had said that the upshot of the statute is essentially that there would only be one provider available in all or most of Louisiana, particularly for later term abortions, but even for earlier abortions. And the way that the statute works in practice is that there are a lot of hospitals that will not give admitting privileges to doctors who perform abortion services. That could be true for multiple different reasons. One is that admitting privileges are often only given to doctors who practice in the hospital. And generally speaking, these doctors do not. Or the hospital may just have a rule that says we won't give admitting privileges to doctors who perform these services. And so there's a debate in the court over really how hard the plaintiff doctors tried to get privileges. The district court said that it would have presented an enormous obstacle to them being able to be licensed in the state of Louisiana. So the case gets, after the Fifth Circuit upholds it, the Chief Justice provides a fifth vote to the more liberal members of the court to grant a stay, which was an indication that he thought that the Texas ruling by Justice, with Justice Kennedy in the majority, and an opinion by Justice Breyer, was going to end up controlling the case, and that's how it turned out. So the Supreme Court, by a vote of 5-4, the four more liberal justices and the Chief Justice votes to strike down the Louisiana statute, and it happens in two separate opinions. Justice Breyer interprets the Supreme Court's abortion precedents essentially kind of from scratch, and says this is the kind of statute that is invalidated by the court's interpretation of the Constitution in the famous Casey decision, because it imposes an undue burden on women's right to access to abortion. He says that what we do here is we look at the burden, and it will substantially, make it harder to get access to these services, and versus the benefit. And he sees no material benefit whatsoever because there's no evidence that says these abortion admitting privilege statutes make abortion a safer procedure. Justice Breyer also rejects a set of standing objections that says that by the state here that the doctors don't have standing to assert the rights of the women whose access to abortion is assertedly constrained by the statute. The vote that really matters, however, is the Chief Justice's, how it is that you get a fifth vote in the Supreme Court. And the Chief Justice says, look, the Texas case controls this one. They're just indistinguishable. And I think this is reflective of the thing that Sarah and I have talked about in terms of the Chief not wanting the court to appear that it's political, that it moves based on its precise appointments or retirements. And he says, we've got this precedent and it's on point, and therefore this statute is invalid for the same reason that the earlier Texas one was. But far more significant for the course of abortion litigation in the courts, the ability of states to impose restrictions, the Chief Justice says I don't think the Texas case is rightly decided. I didn't think it then, I don't think it now. And this is not how I think our court should be looking at abortion cases. And in particular, he says what we are not looking at here is shouldn't be looking at is an attempt by the judiciary to weigh benefits and burdens. I don't think this is that you've shown that this is a sufficient obstacle to access to abortion, and I don't think the state has to prove up a case about why this is beneficial. And what this means, I think, is that although Louisiana lost here, it is a signal to state legislatures in more conservative states that want to adopt restrictions and want to adopt restrictions that are kind of intended to discourage or denormalize abortion, that those statutes are likely to be upheld when it is that they have kind of a cultural, social influence on women's decision whether to choose in particular. I don't think that the opponents of those statutes and abortion rights advocates will be able to get a fifth vote in the Supreme Court. So it's a kind of mixed bag. I am sure the conservatives are disappointed in the Chief Justice's vote. On the other hand, they have to be greatly heartened by the fact that he adhered to his view about the Texas statute and the kind of framework for evaluating these kinds of cases. Pro-choice advocates have to be pleased to have kind of dodged a bullet, if you will, in this one case, but have to be extremely worried about kind of where the court will go when it comes to further restrictions. On the other hand, I don't see in the court's decision a desire, for example, or a movement to overrule Roe versus Wade, to overrule Casey, as opposed to the Chief being more willing to interpret it narrowly. Some of the conservatives would have adopted the standing objection, which would make it much harder to challenge abortion restrictions because those lawsuits do tend to be made by the doctors themselves as opposed to the women seeking the services. And also, we did see here another example of the phenomena that I mentioned with respect to the Bostock case, where Justice Kavanaugh kind of sketching out a middle ground and saying, I would not invalidate this statute because I don't think a record has been made sufficient to show that it has that serious an effect on access to abortion services. And we don't really know how far Justice Kavanaugh is willing to go in a later case. So overall, a mixed bag, but in general, if you were to say which side ultimately ought to be more heartened by this, not surprisingly, given the way the court has been moving ideologically with its appointments, I think actually kind of the pro-life, pro-abortion restrictions side is happier in the end.
Yeah, so your point about Justice Roberts' opinion being more about institutionalism and stare decisis than anything else is obviously a really critical one. Do you see this trend changing at any point before there is a kind of reliable fifth vote in favor of abortion rights advocates? Since what you said, future cases with facts that are at least different enough from this case, and whole women's health will likely go the other way.
No, I think that the time that you will see a more pro-Roe, pro-choice ruling from the Supreme Court is if a state Supreme Court or a court of appeals just gets way out in front of its skis and upholds something that is, a restriction on abortion, after a few weeks past conception or something like that. But I would be surprised to see that. Instead, I think you will see the Chief Justice kind of steady progression where states adopt marginal restrictions, and the Supreme Court by 5 to 4 votes continues to uphold those and continues to kind of narrow Casey and narrow Roe. I don't think it would be very surprising to see the Chief Justice provide a 5th vote for something that's extremely aggressive and a very significant narrowing of Roe, including because that would be contrary to this idea that he's an incrementalist, that he doesn't want to interject the Supreme Court into major political disputes, and he doesn't want to be seen as radically departing from prior precedent.
That makes sense. Sarah, do you want to help us move on to the Trump taxes case? We have a few more things on to cover and not a lot of time left.
Yeah, let me just make one note about the June medical case, which is, as Tom mentioned, stare decisis is a big ticket topic with the court these days, and it expresses the concern of some people on the left that the court will overrule Roe versus Wade or Casey. You also saw that play out in the case we're not really going to talk about, but called Ramos versus Louisiana this year, about whether you can have a criminal conviction based on a non-unanimous jury. And in that case, the court overturned precedent from the early 70s saying that you could, now saying you can't have that. You can't have a conviction without a unanimous jury. And the Chief Justice was in the dissent in that case. It was his only other dissent other than the Indian law case that Tom mentioned. And I think that's him really putting down a stake, saying we're going to stick with our precedent. And interestingly enough, in that case, there was a big debate about whether the prior decision that was overruled, which was like June Medical, a 4-1-4 decision, where the 1 is the controlling opinion, whether it was even precedent that should be adhered to at all. And there was sort of a vigorous debate about that in that case, which seemed strange to me at the time. And then we get the June Medical decision, which again is a 4-1-4 decision. And it sort of, I thought there was some interesting synergy there. Maybe they were looking ahead knowing that that's how June Medical was going to look. So yeah, I'll talk about the subpoena cases. There were 3 cases, 2 kind of grouped together. One is a case brought by Cyrus Vance, who subpoena was issued by Cyrus Vance, who's the Manhattan District Attorney. The subpoenas were issued to various financial institutions seeking personal financial records related to the president and his adult children and some of their business enterprises. The second case is about very similar subpoenas that were issued by Congress to, I think, the same or similar institutions. President Trump, as a human being, not as the president, but intervened to try to quash the subpoenas. In the Vance case, he said basically the president has absolute immunity from subpoenas, state criminal subpoenas, while he's the president seeking information about him. He lost that argument below. In the congressional case, initially they argued very aggressively in the lower court, saying Congress has no authority to request information about the president except through the impeachment process. But then later said, you just have to, there's sort of a high bar for showing a legislative need for these kind of documents. So these cases all came up to the court. They were argued in the May sitting and the telephone arguments. And ultimately the president's, and with support from the Solicitor General, those extreme positions were rejected. And the court adopted, at least in the congressional case, kind of a middle ground, and less of a middle ground in the Vance case, and sent them back. And so in the Vance case, basically, the president had argued that, again, he can never be the subject of the state criminal subpoena. The Solicitor General had not endorsed the idea of absolute immunity, but had said that the grand jury, that the prosecutor would need to show a particularized need for information for the grand jury and show that it could not get that information anywhere else. The court rejected both of those positions and said basically, like, history has shown us that these kinds of subpoenas for grand jury proceedings are not going to disrupt the presidency, are not going to bring sort of undue shame and stigma on the president while he's the president, and so it's perfectly fine to proceed with them in the usual way. The court sent the cases back and said basically any state law privilege that could be asserted by another person can be asserted by the president to try to quash these subpoenas. That would include things like harassment and bad faith. And the arguments had been made that these sorts of subpoenas would be used as a tool of harassment against presidents. If DAs in liberal counties all over the country issued them against Republican presidents, and the reverse against Democratic presidents. And the court said basically, harassment is always a reason you can give to try to quash a subpoena, and there's no difference here. They can try to make that argument, and they could say, that could include an argument that the subpoenas are an attempt to influence the performance of the president's job. That could be sort of a reason that a subpoena was harassing or issued in bad faith. And so the court sent that case back for sort of litigation about the particular subpoenas. And interestingly, the parties then asked the court to issue the mandate, which is like the thing that allows the lower courts to actually do something on an expedited basis. So normally, I think it's 25 days after the opinion is issued. Tom's nodding, so 25 days that that the mandate is issued, and then the lower courts can take it from there. And the Vance came into the lower courts and said, look, we're going to be up against a statute of limitations problem here. He hasn't identified what crimes he's investigating, nor should he, because grand jury proceedings are secret. But he has said, there's some need to move things along. And so, and Trump agreed to that. And so they issued the mandate and have agreed to an expedited briefing schedule below. And so I think that case will move along. That doesn't mean we're going to see any of those records, because even if they are eventually turned over, they're going to be turned over to the grand jury. As I mentioned, grand jury proceedings are secret. And so that case is not going to yield any new information about the president's taxes or financials, certainly before the election. The other cases are the House of Representatives cases. And there, the question was whether sort of the extent of the House's power to seek personal financial information about the president in pursuit of its legislative functions. It had said it was seeking the information as part of an investigation into the adequacy of current government ethics laws. The president had pushed back and said, you can only do this if it's absolutely necessary. The SG had argued for kind of a heightened burden that you had to show that it was demonstrably critical to the House's purpose. The court didn't go that far, but it also declined to adopt the House's invitation to rule that the fact that the president was the subject of the information being sought was irrelevant, and basically said, like, we're going to send it back for the court to consider various things like the purpose of the request, the burden it would place, the scope of the request, things like that, to determine whether these are reasonable requests. The court did say, and this was a 5-4 decision, both of the decisions were 5-4 with the Chief Justice and the former liberal justices. And they said, the House cannot seek this kind of information for investigatory purposes, but only for legislative purposes. And so on remand, there's going to be an evaluation of whether these are in fact valid legislative purposes. And then more recently, the House asked that the mandate be issued on an expedited basis so that the cases could roll along. The president resisted that request, and the Supreme Court declined it. And so there's going to be a bit of a delay in those cases. And so I think that is probably going to mean that nothing will come out before the election. I guess things could happen super, super fast when it finally gets back down there, but that seems pretty unlikely. And so I think this case is another example of the chief as an institutionalist. There's in the decision in the congressional cases, there's like a long explanation, a long recitation of how in the past the legislative branch and the executive branch have worked it out, have like sat down at the table and compromised and figured out how to deal with subpoenas that the executive didn't want to comply with. And he seems pretty irked that they were not able to do that in this case, and that the mess kind of ended up in the lap of the court, which of course has resonance with the DACA case and the census case and some other cases. And so he ended up adopting kind of a middle road here, which is, it's mostly a loss for the president, I would say. Like, the president was asserting these kind of extreme views of absolute immunity for the president. But in terms of the practical effect, it's a little bit of a middle road and kind of kicks the can down the road far enough that it's unlikely to have to reveal any information before the election.
I wanted to talk more about that, but we're running low on time, so I want to make sure that we leave at least a few minutes to discuss the religion cases and specifically what they mean for some important trends for the court. Tom, would you see if we could do this in a 4-minute rapid fire?
Of course. So religion is really the space, as I mentioned in passing, that the Supreme Court's conservatives are probably moving the law the most. Kind of reduction in the wall separating church and state and expanding free exercise rights. The Supreme Court this term had 2 cases, one called Espinoza and one called Little Sisters. And the Espinoza case holds that a state's so-called Blaine Amendment, which says that the state cannot provide financial assistance to religious organizations, is unconstitutional itself insofar as it prevents the state from giving aid just on the basis of religious status. So here you had a state program that said if you donate money, you're going to get a 1-for-1 tax benefit. And when it was applied, the state Supreme Court said that's unconstitutional under the state Blaine Amendment if you are giving the money to a religious school. And the Supreme Court, 5-4, says, no, you cannot have a rule that says we're going to give you a tax benefit if you donate to a private school that is secular, but not one that is religious. That discriminates just on the basis of religious status, and that is unconstitutional. And that's going to have a lot of implications for a lot of governmental programs down the road, and stands for the proposition quite broadly that the state can't say we're going to give out money except to religious organizations. And I expect that in the context of vouchers and lots of other things to be very significant going forward. And it shows 5 members of the Supreme Court being really solidly behind an anti-discrimination principle. The second case is the Little Sister of the Poor case. And this is the Affordable Care Act's birth control mandate coming back to the Supreme Court for the 3rd time, only the 2nd time that it's actually decided. The most famous case being the Hobby Lobby case, which recognized a right to articulate a religious objection to complying with the birth control mandate. This case involved the Trump administration affirmatively enacting by rule a set of exemptions that says you can, on the basis of religious objections, not provide birth control coverage to your employees. And the Supreme Court upholds that set of rules and says that the administration can create that exemption. But there remains to be decided on remand the question of whether a precise scope of these rules is arbitrary and capricious, for example, by allowing major corporations to claim a religious objection. But again, the court's conservatives are solidly behind this recognition of a religious exemption, and the 2 cases together, I think, are a strong indication that there is a very solid majority on the Supreme Court for recognizing that religious concerns have to be accommodated in a variety of contexts. And as we said, that's likely to play out as well in the Title VII context. So, if you were looking at trends at the Supreme Court, you would look at some things that are much more modest, some things that don't seem to be moving the law a lot yet, for example, the abortion case. And on the other hand, you would look at the major movement in the law probably being in religious freedom.
Absolutely. I unfortunately can't continue that conversation because we have a few remaining announcements, but I appreciate you opening that up, and I really encourage folks to read all the really thoughtful commentary on SCOTUS blog relating to these particular opinions. It's a very interesting area of law that's going to be have some major implications moving forward. So before we break, I want to share a couple of opportunities with the group. First of all, it was really a pleasure and an honor to host this conversation. My company, Casetext, is very, very happy to partner with SCOTUS blog. If you're not familiar with Casetext, we provide free access to legal materials to lawyers and the public, along with advanced legal research technology to over 6,000 law firms and many of the country's most accomplished litigators. We this year launched Compose, a technology that assists litigators in drafting consistently excellent briefs faster and at a lower cost to clients. And I really encourage you to look into that if you're interested in that sort of technology. To learn more, just go to compose.law and you'll be able to explore it there. The reason I wanted to flag this today is because we have several programs. First, in light of the opinion in Bostock, extending Title VII rights to claims of discrimination for gender identity and sexual orientation, we're making our composed product for Title VII claims specifically free for anyone bringing claims that are newly cognizable under the statute. So I really encourage you, if you practice in the employment law and specifically discrimination space, to go to compose.law and check it out. It really is some pretty impressive technology. And also, in light of the current spotlight on issues of systemic racism and the continued arrest of protesters exercising First Amendment rights throughout the country, we're also offering free access to basic legal research for attorneys representing protesters or victims of police misconduct. So if either of those programs apply to you and you're interested in exploring them, please do go to compose.law or reach out to my team at support@casetext.com, and we'd be happy to help you with that. Tom, Sarah, thank you both for your time and your thoughtful commentary, and I hope everyone has a wonderful day, and please stay safe.
Thank you.
Thank you. Bye.
Have a great day, everyone.